Good morning to all of you. Welcome to my ethics class. Friends, we all know we are discussing the problems that is part C. I have already told you two problems in the question paper of 2021. Now we are discussing the other problem, that is question number 17. Question number 17, the brief facts of the problem are like this. A judge is related to the advocate. And incidentally, the matter filed by the advocate came before the judge. If the judge takes up the matter, whether it comes under professional misconduct or not. Simply to say, these are the brief facts of the case. I do not have the question paper with me. That's why I am giving you only the brief facts. So here, there is no rule that father and son should not be advocates. We have seen so many families, father, son, son-in-law, daughter-in-law, so many people, they are advocates, they are all practicing in one office. And section 32 of the Advocates Act says that even the court can allow the appearance of non-advocate also. But here the problem is the relationship. So whenever any judge is related to you, whenever any party is related to you, as per rule 6 of the ethics rules, or BCA rules, we can say simple, yes, you should not attend the court. Now I will read rule number 6. Rule number 6, an advocate shall not enter his appearance. So, shall not enter his appearance, act or plead or practice in any way before a court, tribunal or authority mentioned as per section 30 of the Advocates Act. Section 30 says you can practice in any court in India if the sole or any member of his relatives. So if any member or sole member is related to the advocate as father, grandfather, son, grandson, uncle, so many, brother, sister, daughter, aunt, niece, father-in-law, mother-in-law, son-in-law, brother-in-law, daughter-in-law, or sister-in-law, so many relations. So please remember, as when you are having the relationship, you cannot enter in the particular field. But here the problem is very typical. The lawyer is related to the judge. There are so many advocates whose spouses are judges. So wife may be a judge and husband may be an advocate. In such a case, what to do? So better to recuse as per rule number 6. So this is interpretation. You have to interpret the law here, because rule number 6 says only when your family members or relatives or parties to the suit, you should not appear. But they have not specifically mentioned that whenever your relative is a judge, you should not appear. But the interpretation should be like this: you cannot appear. So this is what is stated in the famous case of Sachendra Narayan Singh versus Ramnath Singh and others in 1984. In this case, what happened is actually the son filed the case. So father is working as a high court judge. Son is working as an advocate. Of course, the son normally he doesn't appear before the court of his father, but he attends before the other judges' courts. But incidentally, he filed a case before some other judge. The matter was remanded, or the matter was he has come to the bench of the particular father. Then father wanted to take up the issue. Ultimately, on seeing the name of the son, then he recused himself. Of course, before the advocate appeared before the father recused from the case. But of course, there are so many litigants, they filed petitions against the father and son. Ultimately, the BCI concluded that it's not professional misconduct because father recused already from the case where his son is appearing. This is a classic case. To conclude, I want to tell you that when, as per rule number 6 of the BCA rules, if any relative is involved as a party, maybe as the plaintiff, maybe as the defendant, maybe as the appellant, maybe as the respondent, maybe the complainant, maybe the accused, you are not supposed to take up that case. If you know this much, this is sufficient. I hope I have answered. And please remember the case law, Sachendra Narayan Singh versus Ramnath Singh and others, 1984. Okay, with this I am concluding. Thank you very much.